Problem with electronic things, isn't it?
Court rise.
Good, well let's hope for fewer interruptions this afternoon.
My Lord, I was going to start by addressing my lady's point about the nature of the obligation on the part of the employer in the overarching contract.
Yes.
And if I could take you, please, to Authorities Bundle, tab 23.
So this is Cotswold.
This is Cotswolds. And can I ask you to go straight to paragraph 49, please? And so it's page 299 of the using the bundle pagination. And you'll see in paragraph 49, Mr. Justice Langstaff is addressing a submission based on Montgomery. And then do you see just after the quote from Montgomery, it says later he referred to the ready-mix concrete test as permitting a tribunal appropriate latitude in considering the nature and extent of mutual obligations in respect of the work in question and the control an employer has over the individual. So you shouldn't set the threshold too high. This is what he then says. Although we accept that there is room for the obligation resting upon an employer to vary as between the provision of work, payment for work, retention upon the books, or the conferring of some benefit which is non-pecuniary, we cannot see that such elastic as there may be in the idea of mutuality of employment obligations can be stretched so far that it avoids the necessity for the work the employee to be obliged to provide his work personally. And it says service, the idea of personal service is at the heart of the employment relationship.
Yes.
So just pausing there, bear in mind this is in the context of he's here addressing the overarching contract. And he is pointing out that one shouldn't set the threshold on the part of what you're looking for from the part of the employer's obligation too high. It can vary. Provision of work, payment for work, retention upon the books. In our case, part of the consideration is the retention of the referee on the list, which of course comes with both pecuniary and non-pecuniary benefits. Just pausing there, my learned friend in his skeleton argument at paragraph 24 asserts that Mr. Justice Langstaff has erred in law here. In my submission, there is no basis for that. It's a clear statement of principle, and it reflects ready-mix concrete. Can I just give you a reference, please? You'll see that Mr. Justice Langstaff was himself making these observations in the context of what ready-mix concrete had said about the latitude provided. Can I just give you the reference? It's 515E of ready-mix, where the phrase used is or other remuneration, and that's in the context of the consideration. It's expressly put in ready mix that you're looking at the consideration. So that's why in our case, the obligation on the employer or on the engager PGMOL in the overarching contract, on the FTT's findings of fact, was made out. And then do you see, can I take you to paragraph 55 of Cotswolds? And I alluded to this earlier, 55. We are concerned, this is the, is he then the president of the, is he the current, the then or the future president of the Employment Appeal Tribunal, saying, we are concerned that tribunals generally, and this tribunal in particular, may however have misunderstood something further which characterises the application of mutuality of obligation in the sense of the wage-work bargain. That is, that it does not deprive an overarching contract of such mutual obligations that the employee has the right to refuse work, nor does it do so where the employer may exercise a choice to withhold work. The focus must be upon whether or not there is some obligation upon an individual to work and some obligation upon the other party to provide or pay for it. So 2 points. That's important to remember that's in the context of an overarching contract. 2, he identifies that this is an error, focusing on the no obligation to offer or accept clause. That the focus on that is an error, a common error upon tribunals. And 3, he makes clear that actually the focus should be upon whether or not there is some obligation upon an individual to work. And you do not have that analysis in the FTT's decision. Moreover, that last point about some obligation upon the other party to provide or pay for it has to be read in the context of what he says in paragraph 49. Where we know that the or pay for it can include retention upon the books or the conferring of some benefit which is even non-pecuniary. And in my submission, that is the error, that error that Mr. Justice Langstaff identifies as a common error is the error that the tribunal in our case has fallen into. And that focus on the no obligation clause is the reason for that. And you have my submission that, so we've identified what the obligation is on the employer. Sorry, in here, irrespective of any obligation to provide, you've got the retention on the books and the other pecuniary benefits. So then you look to see, is there some obligation on the part of the individual? And here, as I say, that obligation is clearly to be regularly and readily available for appointment.
What about obligations to do things like have fitness tests and those sorts of obligations?
So they feed into it, but the obligation must be to work. So the obligations for fitness tests and so on, I think on their own would not be sufficient, because it's got to be the work wage bargain. So it's
or an obligation to keep fit.
Yes, I mean, but this is the point, though, madam, is that you can't. This is the problem with what the tribunal's approach is that they've ignored all of those obligations, And you see, when you look at those obligations, that all feeds in, that you've got to look into all of that. They don't exist in a vacuum. It's all for the purpose of being able to provide work, to be able to officiate. Where is the consideration of that? And sorry, here I mean not consideration in the contractual sense, but where did the tribunal address that? And as I say, in my submission, the reason they haven't is because they're not approaching it in the way that Mr. Justice Langstaff has said should be done. And then that goes back to the code of practice, and you see what they are signing up to. And madam, I think the point that you made just now about why are you committing to keep fit if it's not to? Why is that not part of the work? Why is the obligation to keep fit not part of the work here? You're not keeping fit for the sake of it. And bear in mind that this is a season-long contract, and you're keeping fit, and so you're refereeing almost every Saturday, and you're keeping fit to enable yourself to do it on the Saturday. And you see, that's the distinction with a case like Jessica Varnish's case that is in the bundle. Is there the fundamental work-wage bargain wasn't present because she didn't do any work for I think it's the British Olympic Association, and they weren't under any obligation to pay her. So it's a bit like the Quashie case. The work-wage bargain wasn't there. But that issue just doesn't arise in our case.
Which case are you talking about, please? Which?
Jessica Varnish. It's a judgment of Mr. Justice Chowdhury.
Not in the bundle.
It is in the bundle.
It is. Which?
53.
All right.
And you'll see, madam, that in that case, the key point is it's a bit like Quashie, where they find there is no obligation to pay, and she doesn't provide work.
Okay.
Whereas in our case, you have the undoubted obligation to work on the Saturday in the individual contracts.
Yep.
So you have the work-wage relationship. Can I just finally just take you to auto-cleanse for two reasons. One is that, my Lord, you asked me about the Supreme Court in auto-cleanse yesterday.
Yes, thank you.
And I'm just, so it's tab 31. I'll go through it quite quickly if I may. Using the bundle pagination, page 407. Paragraph 8 sets out one of the key clauses that was an issue. It's a substitution clause. Sorry, that's the no obligation. That's the no obligation on either party. And there's also a substitution clause. But then on the legal principles, it's paragraph 17. You'll see that the issue in that case was, or one of the issues was, it's 17, it's the last line. This involves consideration of whether and in what circumstances the ET may disregard terms which were included in a written agreement between the parties and instead base its decision on a finding that the documents did not reflect what was actually agreed between the parties or the true intentions or expectations of the parties. So that was our alternative argument on the overarching contract that the tribunal rejected. Then at 18, do you see this? As Lady Justice Smith explained in the Court of Appeal at 11, the classic description of a contract of employment is the Miss Justice McKenna in Ready Mix. So that's the Supreme Court's endorsement of Ready Mix, paragraph 18. and then this. Paragraph 19, 3 further propositions are not, I think, contentious. 1, as Lord Justice Stevenson put it in Nethermere, there must be an irreducible minimum of obligation on each side to create a contract of services. 2, if a genuine right of substitution exists, this negates an obligation to perform work personally and is inconsistent with employment status. So that's the personal service point. 3, if a contractual right, for example, a right to substitute exists, it does not matter that it is not used. It doesn't follow from the fact that a term is not enforced, that such a term is not part of the agreement. My Lord, you asked me yesterday whether the Supreme Court had endorsed the particular, I think it was paragraph 74 of Lord Justice Aikins. The answer is that although they refer to almost every other paragraph in his judgment, in this judgment, they don't specifically refer to that paragraph, but you'll see that in 1, they deal with the mutuality obligation, 19 sub 1, they deal with it very briefly, whereas his paragraph 74 is a breakdown of the elements.
Yeah.
So they certainly don't suggest there's anything wrong with it. And I say they agree expressly with everything else, with a number of his other paragraphs.
Incidentally, in little 1, I think contract of services at the end must be a misprint. It must mean service, doesn't it?
Yes.
Yeah. Just to confuse us all.
Whoever invented contract of service and contract for services hasn't done anybody any favours. Then paragraph 20, the essential question in each case is what were the terms of the agreement? And then you see correctly summarised by Lord Justice Aikins in paragraph 70. And as I say, it's paragraph 74 that I cited to you.
Yep.
And then paragraph 21, and then importantly, paragraph 20. So 20 is where Lord Justice Aikins sets out the correct position of construction in an ordinary contract. Then 21, nothing in this judgment is intended in any way to alter those principles which apply to ordinary contracts and in particular to commercial contracts. There is, however, a body of case law in the context of employment contracts in which a different approach has been taken. Again, Lord Justice Aikins put it correctly in the remainder rating as follows. But in case of contracts concerning work and services, where one party alleges the written contracts do not accurately reflect the true agreement, rectification principles are not in point. There may be several reasons why the written terms do not accurately reflect what the parties actually agreed. But in each case, the question the court has to answer is what contractual terms did the parties actually agree? And this in 22, in this context, there are 3 particular cases in which the courts have held that the ET should adopt a test that focuses on the reality of the situation where written documentation may not reflect the reality of the relationship. And then do you see at 25, they say paragraphs, they're citing Ms. Justice Elias in Calwack. It says 25 at paragraphs 57 to 59, Elias J said this, the concern to which tribunals must be alive is that armies of lawyers will simply place substitution clauses or clauses denying any obligation to accept or provide work in employment contracts as a matter of form, even where such terms do not begin to reflect the real relationship. And then you see sub 59 in 25, that Peter Gibson in Tanton, sub 59, tribunals should take a sensible and robust view of these matters in order to prevent form undermining substance. Then 26, Lord Clark approves that approach. And then 29, again he approves that, and also the approach of Lord Justice Aikins. And then again at sort of paragraph 33, he agrees with Lord Justice Sedley, recognising that while employment is a matter of contract, the factual matrix in which the contract is cast is not ordinarily the same as that of an arm's length commercial contract. I agree. The critical difference between this type of case and the ordinary commercial dispute is identified by Lord Justice Akins in paragraph 92 as follows. And if one looks at the final sentence of that quote, the court or tribunal must be realistic and worldly wise when it does so. Sorry, I mean the whole quote pays reading. Very different from those in commercial contracts between parties of equal bargaining power. So the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what was agreed, and the true agreement will often have to be gleaned from all the circumstances. This may be described as a purposive approach, content with that description. Just pausing there, not only does that apply to looking at whether the terms reflect the reality, but that must a fortiori apply to when you are construing the terms. So the fact that a lawyer has labelled something expectations, one has to take a realistic and worldly wise approach to the construction of the document. You are not construing a commercial contract.
I'm finding all this very puzzling. I mean, firstly, I rather jib at the notion one should not be realistic in construing a commercial contract. And secondly, I mean, is not part of the reality here that we're dealing with these highly motivated referees who are very much a special category, unlike, you know, casual workers in almost any other context one can think of.
But with respect, in those other casual workers' contracts cases, the courts found that both parties were content to have their relationship between the gaps not regulated by contract. Yeah. Whereas in this case, we know that PGMOL were not content to do so. They entered into detailed contractual documents. They entered into a contract with detailed contractual provisions.
Well, absolutely. And the question is how far the
Yes.
strictly contractual element went. And I mean, that's where they drew a line.
But with respect, in this case, as your lordship put to me earlier, expectations is ambiguous. It can mean either an obligation or not an obligation. Here, correctly construing that document in the context, in circumstances where the referees are, at the end of it, it's an offer, and they are required to sign it at the end to say that they accept the offer on the terms set out in that agreement. One of those terms is that they will be readily and regularly available throughout the course of the season. And with respect, the only point that the tribunal identify in the document going the other way is the no obligation clause. And in my submission, the correct construction of that clause is, as was said in Pimlico Plumbers by the Master of the Rolls, it cannot be that the referee was able to refuse any and all engagements across the course of the contract. And I do rely on Mr. Justice Langstaff, paragraph 49, and in particular on this point, 55. Lord, can I should say that the Supreme Court in Uber have recently approved, have recently approved what they said in the auto-cleanse, that auto-cleanse is the correct approach. Can I move on to control?
Yes, thank you.
So again, just to put it in context, control is Millennium Friends Respondent's Notice. The Upper Tribunal found that the FTT erred in law and took into account irrelevant considerations in concluding that there was not sufficient control to satisfy the RMC Lim 2 test. Importantly, in their skeleton argument, Millennium Friends on control do not cite any authorities for the principles they assert. There is one reference to Montgomery, but you'll see that they don't cite any authorities for the relevant principles. My Lord, hopefully you have our supplemental skeleton argument, which addresses the issue of control.
Yes, we do. Thank you.
And that's what we have sought to do in there is set out the authorities and the relevant principles in this area. So, taking those as read and in view of the time, can I just go to a few authorities, please?
Yes, of course.
Can I first go to tab 45 of the authorities bundle? This is Mr. Justice Langstaff.
Sorry, I didn't catch
Apologies.
which tab you said.
45.
45.
45.
It's at the end of volume 2, at least.
Oh yes, thank you.
My one. This is E. Right and Aegis, is that?
That's correct.
Yeah.
I say I'll try and take it quickly, but can I first ask you to go to paragraph 13? Starts with, so this is commenting on the ET decision, starts with ready-mix concrete in 13. And just to note that this is an overarching contract case, unfair dismissal claim. Paragraph 14.
So what did the claimant do? Sorry.
So he was a security. He worked in security overseas.
Right. Thank you.
See, in the second sentence, I note that those are two positive requirements. So, sorry, the judge expanded upon what may be said about categories 1 and 2. So that's RMC Lim 1 and Lim 2. Then Mr. Justice Langstaff says this: I note that those are two positive requirements. So Mr. Justice Langstaff is saying that Lim 1 mutuality, Lim 2 control are positive requirements before a contract may be classified. And he says, I emphasise the word may as a contract of employment. And then he says this: the third criterion, so that's ready mix 3, Lim 3, is in essence a negative one. That is, that the other provisions of the contract do not take a contract in which there is a mutual agreement to provide work, employee, for money, employer, which is to be under the control, Lim 2, to a sufficient degree to make one a master and the other servant outside the definition of a contract of employment. There may be situations of which ready-mix concrete itself was an example, in which, notwithstanding the two conditions 1 and 2, necessary for there to be a contract of employment, the contract was not properly to be classified as such. So there you have, again, consistent with ready-mix concrete, an explanation of the interrelation of the three limbs of the test. 1 and 2 are positive conditions, and limb 3 is a negative requirement. Can I then ask you to go to paragraph 35, please? And again, by this time, Mr. Justice Underhill, I think this was after he'd been president, so he'd no doubt basing this on his experience from his time as president, maybe before. As to control, there have been a very great number of cases relating to employment status which have come to the EAT in which it has been clear that the employment judge has looked to see whether control has actually been exercised as a matter of fact in practice. It seems that in some of those cases, much of the discussion has been related to whether the evidence shows that orders have been given or not, and whether the claimant has or has not availed himself of the rights that one might expect an employee to utilise or have. This approach concentrates upon practical manifestations of day-to-day control and not upon the contractual entitlement to which McKenna J drew particular attention in what he had to say, yet it is this which is critical. he was speaking about rights by reference to zoos. Zoos is a case which was decided by the High Court of Australia, but is of great use in this context to return to it knowing that the essential principles within it has recently had the endorsement of the Court of Appeal in White and Troutbeck. Then 37. The case deals with the problem of seeing an employer having control in any meaningful sense over someone who has more skills relevant to the task in hand than does the employer. The particular case of Zeus involved a claim by an acrobat for compensation. So, again, no suggestion that the engager could intervene mid-act to exercise control over the acrobat. And then do you see this just above 37, quoting from the judgment in Zeus, a false criterion is involved in the view that if, because the work to be done involves the exercise of a particular art or special skill, and then this is important, or individual judgment or action, the other party could not in fact control or interfere in its performance. That shows that it is not a contract of service, but an independent contract. So he's saying that's a false criterion. And do you see paragraph 38? Mr. Justice Langstaff gives the examples of football players, the occasions in which they may be required to exercise them often involve judgment and such are not susceptible to intimate direction by employer. Paragraph 40, he gives the chauffeur analogy. He says, thus the question doesn't depend, as the case is made clear, upon the practical demonstration of control by drawing attention to particular instances when control has or has not been exercised, but rather to what is known of or may be inferred as to the contract between the parties, which is said to give rise to the right in the employer to direct in relevant respects. So we're looking at direct. And so 41, the old-fashioned phrase, focus upon the relationship being one in which the power to direct the other may, by use of the terminology be obscured, the right in one to direct the other. What matters is the power to direct, as Mr. Justice McKenna pointed out. And you'll see in that case, he said the contract is clear as to this power, inescapable as the term of the contract that the employer here had the power to direct and the employee had bound himself to observe that direction. Simply unarguable that the contract didn't contain sufficient by way of control. If you recall yesterday, I, when taking you to market investigation, said that there was something relevant in there. It's tab 9. And the relevant page is 185E. If you recall it, this was another one of the market research cases. Page 90 of the bundle pagination.
Thank you. So just at E, what Mr. Justice Cook says is, the facts found by the Minister show that the control of the company is exercised at 2 stages. Before the interviewer engages herself for the particular survey, she will probably have seen the company's interviewer's guide. This document contains detailed instructions. It sets out some of those instructions. Then in the next page, on the Minister's findings, I have no doubt that the instructions in the interviewer's guide, after having been seen by the interviewer, are incorporated into the terms of any contract which the interviewer may thereafter make with the company to participate in a particular survey. And you have, in our case, that documents such as the match day guidelines were contractual documents which were incorporated into the individual contracts. And with respect, that is how, where you've got real-time performances,
That's typically how an engager will exercise control, by having those sorts of guidelines which the individual here, the referee, is contractually required to follow. And do you recall it in those findings of fact in relation to the match day guidelines, the FTT found, yes, they often reflected the rules, but PGMOL made those contractual so that they were owed, the referee owed it, PGMOL, a specific commitment to follow them. Can I then just finally on authorities take you to Uber, which is tab 55, please? This is page 937, bundle 937. So context here is this is a worker case, but it is the last word we've got from the Supreme Court on the issue of control. So therefore, my submission relevant when you see the terms in which how they approach this, relevant for you. Paragraph 75, the correlative of the subordination and or dependency, and this is important, of employees and workers in a similar position to employees is control exercised by the employer over their working conditions and remuneration. So he is expressly, Lord Legger is addressing both employees and workers. Then paragraph 87. At G, you see he says, the touchstone of such subordination and dependence is, as has long been recognised in employment law, the degree of control exercised by the putative employer over the work or services. Sorry, so this is at G, page 940, so it's paragraph 87 at G. The degree of control exercised by the putative employer over the work or services performed by the individual concerned. And again, the reference to employment law. Then paragraph 93, you will see that the Supreme Court identified 5 aspects of control found by the ET in that case. You see, the first one is 94. First, and of major importance, the remuneration paid to drivers for the work they do is fixed by Uber, and the drivers have no say in it. That's 94. That's the first of the 5 aspects of control identified by the Supreme Court. Can I just give you 2 findings of fact in our case, references?
Sorry, is it just control we're dealing with here?
Yes.
Sorry. So how do we be sure about that? It just says...
Yeah, can I explain that?
Yeah.
So 93, last sentence, 5 aspects of the tribunal's findings are worth emphasising. 94 starts first, of major importance. If you look at 97, it says the second form of control is exercised by, and as I take you through the other ones, 3, 4 and 5, it's clear they're all aspects of control.
All right.
So 94.
Oh, I see. So I'm...
Apologies.
Well, I'm not altogether here, but maybe it's that line at the top of that page, the principal relevance of the involvement of third parties, i.e. passengers, is the need to consider the relative degree of control exercised by Uber.
Mr. Pennell tells me to look at 94E. Uber's control over remuneration further extends to the right to decide in its sole discretion whether to make a full or partial refund of the fare.
Yes.
So just to make clear that it is dealing with control.
Because
So-
the wider context is an argument that the drivers are really working for the passenger.
Exactly.
I suppose that's right. Yes, I see. Thank you.
And that was the reason for taking to those earlier paragraphs where they're saying subordination, the correlative is the level of control.
Yes, thank you.
So 94, can I just give you two FTT references, please? FTT 128 and FTT 55. Those are our tribunal's findings that the match fees were fixed by PGMOL and were announced to the referees at the annual conference for the forthcoming season.
128 and 55 was that
Sorry,
the second one?
128 and 55.
Yep, thank you.
Then can I take you to 90? So 97 is another form of control identified. Then, do you see 98? Again, Uber exercises a significant degree of control over the way in which the drivers deliver their services. So that goes back to the match day guidelines. Sorry, the match day guidelines. Then, sorry, match day procedures. Then 99, this is important. 4 lines down, a further potent method of control is the use of the rating systems, whereby passengers are asked to rate the driver after each trip, and the failure of a driver to maintain a specified average rating will result in warnings and ultimately in termination of the driver's relationship with Uber. A bit lower at G, it draws a contrast with Amazon and so on, where you rate something, typically goes to sales, but it says G, the way in which Uber makes use of customer ratings is materially different. The ratings are not disclosed to passengers to inform their choice of driver. Passengers are offered a choice of driver with, for example, a higher price, etc. Rather, the ratings are used by Uber purely as an internal tool for managing performance and as a basis for making termination decisions where customer feedback shows that drivers are not meeting the performance levels set by Uber. This is a classic form of subordination that is a characteristic of employment relationships. Just pausing there, you've got the FTT's finding that here, the assessments that were made of the referees went to 2 things. One, their place in the merit table that determined how much of the performance pot they got at the end of the year, so the bonus. But 2, it also went into determining what matches they would get going forward. So it's used in exactly the same way. But in our case, the tribunal say that's irrelevant as a form of control because it's not exercised during the engagement. But remember, Uber, I showed you when we were looking at Lim 1 and 2, Uber wasn't an overarching contract case either.
Can you just remind what paragraphs those?
90 and 91.
91, thank you.
That's right. Oh, sorry, madam, you mean in Uber? Do you?
No, in the FTT decision.
I'll
you said
come-
the FTT.
yeah,
you're going to come to
I'm
that.
going to
All
come to that now.
I'm so sorry.
No.
I mean, on all this, you have the Upper Tribunal's decision in your favour. So,
I do,
in a sense,
but-
you're getting our retaliation in the first. Is
No.
this the idea?
No, for this
I mean,
reason.
why are we going through all this now?
For
then?
this reason, the Upper Tribunal didn't substitute their own decision.
I know. Yeah.
And the point for showing you this is to show that on the findings of fact, the only answer was that there was the sufficient level of control.
I see.
So that, and remember, the only reason they didn't substitute their own decision was because of Lim 1. And so they said, well,
Well, they had a choice.
They did have a
to deal
choice.
with it themselves or remit, and they didn't. I mean, they
And-
could have done either.
absolutely.
Or at
And
least
they-
maybe-
And they suggested, well, it could go, there could be many options. But in my submission, when you read the paragraphs, looking at the authorities I've taken you to about what is required, a sufficient framework of control, when one looks at the findings, that's the only permissible conclusion on the facts. If I can ask you to just have a look at so the relevant paragraphs in which they deal with this is paragraph 16. And my lord, that's relevant because if you're with me on ground 1, if I'm right about this point that the only permissible finding on ground 2 on control is that there was the sufficient framework, you've seen in ground 3 that we see the tribunal say the other factors point to employment. So that's the reason for taking you to this. And that last paragraph, the reason in Uber, the reason for that is that we have that same thing here. So, can I just go very quickly through the decision? This is the section on control is 163. This is page 41. So, in order for individual engagements to be contracts of employment, must not only be mutuality but a sufficient framework of control. This means some contractual right of control, and then this is the important bit, in the sense of the employer having the right to step in, even if that right is not exercised in practice, and even if the individual is engaged to exercise his or her own judgment about how to do the work. And that comes from the White and Troutbeck case, which was endorsed by the Court of Appeal. The problem is that the tribunal have interpreted that those words in the sense of the employer having the right to step in, literally. As in, has the right to step in the course of the match. And you see that, we'll come on to it, that's what you see in 168 and 169. That's why they ignore all the other factors, and that's also what the Upper Tribunal found. 164, apparently they were submission made that they were like clergy beyond control. My submission was that there was a sufficient degree of control, including by the assessment and the coaching systems, as well as controls imposed by the documents. We agree that the pre-season documents, including the fitness protocol, the match day procedures document, and the code of conduct imposed some obligations on referees, which gave PGMOL elements of control. So you've got the findings here. Some of those obligations applied to match day activity, most obviously the match day procedures, and were therefore relevant to individual match appointments. So there you've got the finding they're incorporated into the individual terms, match terms. Others, such as contact with the sports scientist, clearly didn't apply in respect to the individual match. Then this importantly, although referees were and are undoubtedly subject to both FA and competition rules and regulations while at a match, we have found that they also owe direct commitments, contractual commitments to PGMOL by virtue of the terms of the pre-season documents. So there you've got your contractual right of control. 166. We are not persuaded that the assessment and coaching systems themselves provide further elements of control in respect, this is important, in respect of individual match appointments. So they do in respect of the overarching contract, but not in respect of the individual match appointments. Then this is important because of the paragraph I've just taken you to in Uber. While the assessment system was and is clearly very important and feeds into the merit table, selection for future match appointments, and ultimately the merit payment distribution, promotion and reclassification, it is advisory rather than controlling in nature. Well, as I've said, based on what I've just shown you in Uber about the equivalent one, it's the Supreme Court says it's an important part of control. Here, they say it's not even a matter of weight here. They say it's irrelevant. Similarly, the coaching system is very much personal, advice and not integrated control. 167 is all about what, where, and how. So the point about 167 is that's all about goes to accepting before you accept the contract. Then this is 168 and 169 are the key ones. So this is why they find not employees. So my submission is the findings of fact you have in those earlier paragraphs provide you with the sufficient framework of control. There is the contractual right of control. And that's what enables you to substitute your own decision. Because had they not made the errors in 168, 169, that was the only permissible conclusion. 168, whilst we would not go so far as to compare them to clergy, it is relevant to consider the nature of the role. The referee is undoubtedly the person in charge on match day. He has full authority and his decisions are final. Well, final vis-a-vis whom? Fourth officials answer to and work with the referee, whoever that referee is, and whether he is employed by PGMOL or not. That's a bit odd because here it's not clear who else it is. PGMOL is the only engager. The Code of Practice also recognised the FA alone will deal with breaches of its referee regulations. In reality, it's hard to see how PGMOL could retain even a theoretical right to step in while a referee is performing an engagement at a match. However badly Mr. Riley or anyone else from PGMOL who might be watching thinks that the referee is doing. At most, they could offer advice at the time and then, importantly, and take action after the engagement has ended. So they find they can take action, but they disregard it because it's after the event. In our view, this is the case despite the undoubted fact that the referee might be officiating in a critical match at which large sums are at stake. So here now, it's important that this is commercial and large sums are at stake. Then the laws of the game make clear that the referee's decision is final and that there was no suggestion that PGMOL could remove the referee at half-time and replace him with another or do anything more than offer coaching advice. The laws of the game they're referring to is Law 5 that says
it's offside or whatever it might be. Or yes.
The players and the manager have to respect the referee's decision.
Yeah, which is that really is completely off beam.
But this is why they find that there isn't a sufficient contractual framework. But with respect, I'll make the next point if I may in 169. 169 overall, we're not persuaded that PGMOL had a sufficient degree of control during and in respect of the individual engagements to satisfy the test of an employment relationship. It did have a level of control outside match appointments as a consequence of the overarching contract, although some of the obligations imposed by that contract applied to matches. Underline this bit, there was no mechanism enabling PGMOL to exercise the correlative rights during an engagement. In reality, the only sanction PGMOL could oppose for failures to adhere to these commitments was not to offer future match appointments and to suspend or remove the referee from the national group list. That is your right of control. Then if an issue emerged between a match point being made and the date of the match, then the most PGMOL could do in respect of that appointment was to cancel it. But the fact that you can cancel it is a right of, so again, is a right of control during the contract.
Yes, I mean, it shows, well, to my mind, it shows at the moment that is precisely how control is being exercised.
And then,
suppose you accept your engagement on the Monday, and on Tuesday, PGMOL come into possession of information suggesting there might have been some questionable conduct on the part of the referee in relation to the last match he refereed.
But look at the next sentence, my lord.
Yeah.
But that is not an exercise of control during an engagement.
Well, I mean, it is.
But so you can see why the Upper Tribunal allowed our appeal. But more importantly, in these paragraphs, you have the findings upon which the only permissible conclusion.
Well, that's another question. I mean, we have your submission, and obviously we will have to consider for ourselves, if we get to this stage, whether it's something we can decide for ourselves or whether we think it needs to be remitted.
Yeah, and can I just give you some references on that? On the evidence before them on the sanctions after. So can I just give you the references?
Yes.
FTT 90 is the finding about one of the examples they had of a breach of the match day procedures, and where so that was breach during the match and disciplinary action taken after. And if you wanted to see the sanction letters, it's supplemental bundle tab 17, pages 128 to 132. And you've also got FTT 66 on the PGMOL guidelines, which relate to the match conduct, those directives. And can I give you one further paragraph on the relevance of performance assessment during the match to relevant future appointments is FTT 49. So I'd given you FTT 166, but it's also FTT 49.
Thank you.
So, my lord, I think on disposal you have my submissions that on the individual contract, we say if you find for us on ground 1 and 2 effectively on the individual contract, so there was irreducible minimum. If you, on respondent's notice, if you are willing to, as what we say is the only permissible finding, and then you have the on the third factor, they said those factors pointed to employment.
Yes. If we did come to the conclusion, I mean, on assuming for the moment we were with you on grounds 1 and 2, if we came to the conclusion that the question of control had to be remitted, presumably the FTT is the right body to remit the question to, because they are the tribunal of fact.
It is, but unfortunately, as you know,
yes,
Mrs. Justice Falk is no longer sitting in the
well, I know, but I mean, the fact is, that doesn't necessarily preclude a remission to the FTT. It would just, unfortunately, would have a consequence, unless there is some machinery which could enable her to sit in the FTT. I mean, I don't actually know whether there is or not. That may be a point that could be can be checked at some point.
Perhaps.
I mean, you'll be surprised. High Court judges can sit in the county court. They can do all sorts of things if you have the right authorization can be found.
I understand. I mean, the only other problem is this, and this was the point that I was alluding to that I would come back to, is that this is a tribunal that if you get to that stage, you will have found has fundamentally misunderstood and applied the relevant principles in relation to Lim 1. In relation to Lim 2, has also fundamentally misunderstood and applied the principles in relation to control. Is it appropriate in those circumstances to remit it back to the same tribunal? But also, then, my lord, it's relevant to my third ground, because when you are saying, when in considering my third ground on the overarching contract, and you are looking at whether or not this tribunal did properly apply and approach the contract, the terms, and the irreducible minimum in relation to the overarching contract, you will know that that same tribunal did not do so and fundamentally misunderstood the content of those terms.
So what are you saying? If it goes back, it should go back to a differently constituted tribunal anyway?
I mean, that seems to me the implication of what you were saying.
Yeah.
I think it would have. I think it would have to, given what's happened. But I can see that that's not.
Well,
I can see that's not attractive.
And well, it can be a delicate judgment. I mean, sometimes the need for justice not only to be done but to be seen to be done does make it appropriate to remit to a differently constituted tribunal, which doesn't necessarily involve any particular criticism of the tribunal which has already decided the matter, but just as it were the degree of error which the appellate court has found to be established.
And that's in this case what gives me is why I'm saying it. It's not as if it's an isolated or small error.
Well, yes.
The decision, if you get to that stage, it will be on the basis that the decision is permeated with.
I mean, similar principles apply in the employment appeal tribunal.
Exactly.
Oh, indeed, yes.
Decides whether or not to remit.
Yes.
Exactly.
Yes.
So essentially, it's exactly the same point.
Yeah.
Yes.
I mean, and that often in the Employment Appeal Tribunal, as the lady will know, that is the reason why you do remit it to the new tribunal.
Well, it happens, indeed. I mean, it happens probably much more often in employment contexts than, for example, in the tax field, and even there, occasionally, an error may be so egregious that it's felt appropriate to do that. But normally, if you're dealing with trained lawyers, and of course we are very much so here in the case of Mrs. Justice Falk, one can say that once the law has been put right, then they can analyse the facts accordingly, with the great benefit of having already heard whatever it was, 4 or 5 days of evidence and arguments on the case. Well, we'll have to think about that if we get to that stage.
But obviously that is also an advantage of you substituting your own decision on the control. In circumstances where we do say, as I say, the findings of fact are there.
Yes. Very well.
Lord, unless there's anything further that you wanted me to address you.
Anything else? No, thank you very much, Mr. Norvat. So, Mr. Peacock, the field is yours. When you're ready.
It's nice to be able to breathe for a moment. There is quite a lot of ground I need to cover, and I do need to look at some of the authorities in some detail. But it's important not to lose sight at the outset of 5 things. First, the First Tier Tribunal here did make considerable findings of fact as to these particular class of referees, the 60 referees in the year we're looking at, who had worked their way up from junior football through the pyramid to the League One and League Two of the football league.
Yes.
All of them fitting their refereeing around their day jobs, and found as a fact by the First Tier to be passionate about refereeing, driven to excel, driven to pursue their hobby. And all those findings that you've seen in the First Tier decision were based on having heard evidence from the witnesses, seen some notes of meetings that the Revenue conducted with other referees, and considered all such matters over a 7-day hearing. So there is a considerable factual substratum, all or nearly all of which is not challenged. And whilst the First Tier and indeed the Upper Tier necessarily have to address questions of legal principle, one shouldn't overlook the significant evaluative exercise carried out on the evidence by the First Tier. That's first observation. Second observation, the court is well alive to this, but the appeal from the First Tier to the Upper Tribunal and from the Upper Tribunal to this court is on point of law only. That can be expressed, as it was in Pendragon, as this court contemplating whether the Upper Tribunal had erred in law. In a case of this nature, one may start at the other end of that chain and ask, did the First Tier err in law? And if so, then have the Upper Tribunal failed to identify such an error of law? Yeah. And for my part, I think one could do it either way. It doesn't ultimately matter. Third point is that this is a tax case, not an employment case. Necessarily, we're concerned ultimately with different statutory provisions. Trite law that we must construe statutory provisions purposively, the purpose to be discerned from the words used by Parliament, but the purpose when one comes to look at the authorities in tax cases is not necessarily the same as the purpose in employment cases. So one has to have in the back of one's mind the identification of the relevant statutory purpose that might bear upon the question one is addressing as to employment status.
But isn't there also a sort of instinctive feeling that the law in both fields should be coherent?
My lady, there is.
Right.
But there is recognition in the Supreme Court in Uber that the policy drivers are not necessarily the same. Now, the lady is quite right. It would be an odd state of affairs if the law was different. But one does need to bear in mind that you are asking the same or a very similar question, but in different contexts.
As a matter of tax legislation, what is it we're construing? It's just the word employment, is it?
It is the word employment.
Yes.
There's a slight variation as to whether it's income tax or national insurance, but
Quite. I mean, yes.
And that isn't further defined in any of the tax legislation, is it? No.
Tax legislation borrows from the employment world.
Yeah.
So, and doesn't that suggest that in this particular case, although your proposition may well be right in general, in this particular case, it's hard to see what different purpose one could be looking for?
Well, I accept that, and that's not quite my point. My point is when one comes to read the authorities, one needs to bear in mind that sometimes you're looking at an employment status case where what matters is, are you an employee?
Yes.
So as to acquire certain rights.
I see. I follow, yes.
And sometimes you're asking whether you're a worker,
Yep.
and sometimes you're asking in a tax context where tax doesn't draw the distinction between worker and employee. It doesn't in the same way, at least.
But the word employed, as a matter of statutory construction, you presumably accept means somebody who has a contract of employment.
Yes.
Yeah.
Fourth general point is one does need to bear in mind, and I will look in due course, at what was actually decided in ready mixed concrete and how the judge arrived at his decision. And we are going to have to look at the authorities as to how that was understood since 1968, at least some of them. But there is a danger. There is a danger in attempting that minute analysis of what Judge A said in case A, and a slightly nuanced expression of what Judge B said in case B, and then try and reconcile all of that with some later statement of Judge C in case C. And in this area, it is almost inevitable that exercise has to be done. But one does need to bear in mind that what one is doing is seeking to compare nuanced, slightly different expressions of what was understood with the decision ultimately, as we now know, in ready mixed concrete. So without denying the importance of that exercise, one does need to be alive to the fact, or the possibility at least, that not all of these judicial expressions can necessarily be reconciled.
But isn't the point of the exercise to try and understand the underlying principles?
My lady, yes. And that was going to be my next point, that one can do this exercise in criminology of trying to discern what was meant by a particular phrase in a particular judgment, but ultimately it's a matter of attempting to identify and apply matters of principle. My last general point by way of introduction is that you will now have sensed, at least, and I believe seen on the authorities, that there is more than one school of thought as to what is meant by mutuality of obligation. And that is a debate that has rumbled around in the employment field, both tax and employment cases, since 1968. And whilst there is recognition that it has been used in different senses, in different judgments, there is as yet no definitive statement in this court or above as to the exact role and scope of this concept of mutuality of obligation. And on the basis of what you've heard from my learned friend, you are being asked to decide that question, because all decisions of this court are big and important, but that is a particularly big and important decision you are being asked to make. Now, against that background, I'm going to address the court under 5 broad headings. And I'll enumerate them, though I think it might be easier if I take them slightly out of order. But to enumerate them, there is the role and scope of mutuality of obligation, and that will encompass my learned friend's ground 1. and also what was decided in Uber. So we might as well look at it there. Then we need to apply, I say my submissions about ground 1 to address the second topic, which is individual contract mutuality. That's Malone Friends ground 2. Then I need to address umbrella contract mutuality. That's Malone Friends ground 3. And fourthly, deal with control, respondent's notice. And then lastly, deal with disposal. Now, I had originally thought that it would just make sense to do them in exact that order. There's a logic to it, and it also reflects the order you've heard from Malone Friend. But I wonder, given the time and the best use I might make of this afternoon, if you would indulge me, what I thought I might do is deal with overarching contract mutuality, because there is a short answer to that contention, and then also deal with control. Then I'll come back tomorrow morning and deal with the scope and role of mutuality as a whole.
So you're going to ground three.
I'm going to ground
first.
3
Yeah.
and then control, and then I'll come back and do, I'm afraid, the heavier lifting tomorrow morning. So assuming that the court is content for me to do that, recognising, of course...
Yes, I think it's a matter for you on the whole to decide how best to present your case, and it's not for us, at least I'm certainly not proposing to invite you to do it any differently.
I'm obliged. So, overarching or umbrella contract mutuality. And here it's necessary quickly to remind ourselves what it is that the first tier actually decided. Malone Friend invited you to look at some paragraphs of the first tier, but he didn't show you all of their reasoning in this regard. So can I invite you to pick up the first tier's decision? There's a heading above paragraph 124, internal page 30, bundle page 163. There's a heading discussion. And then the first part of their analysis addresses the question as to whether there was a contract at all with PGMOL. And they reject Mr. Morm's submissions that there wasn't. So the next section is against that background where they've decided that there is a contract. So they then turn to address the contractual terms of the overarching contract, and that begins at 135. So they begin in 135 by recognising that the terms of the overarching contracts can be found largely in the pre-season documents. And the pre-season documents are those documents that they've examined at paragraphs 59 through to 86. (136) records Malone Friend's argument that he was relying on Carmichael to suggest that some additional terms should be inferred from the wider factual matrix. And then Malone Friend also relied on autoclaims. So in 137 they deal with Carmichael, which I'll come to in just a moment, and they identify that the particularly relevant passages were in the judgment of Lord Hoffman. So I'll come to that in a second. So that's 137. They then deal with an argument about implication of terms by Liverpool City Councillor Irwin, that's 138. And then at 139, they identify what it is that the revenue seek to establish, namely, this is line 16, that the behaviour and practice of the parties effectively supplies some of the contractual terms, and the written terms are to be read in the light of this. That approach is consistent with the approach taken in Carmichael, and the question is one of fact. I'll come back and show you why they're right about that. But could you just underline the question is one of fact? 140 then says, well, turning to the facts, we first consider documents and then what terms might be derived from them by way of addition. 141 is their analysis of the written terms, including in 142 their summation of the obligations that were owed by each party under the overarching contract. And Malone and Friends showed you that. And they say in 143 that there are also obligations found in the match day procedures documents, and some obligations found in the Code of Conduct and the match day procedures. So those are their findings as to the terms in the written documents that form part, at least, of the overarching contract. And then from 144 onwards, they are analysing the surrounding factual circumstances to see what other terms might be found to form part of the overarching contract. And in particular, they record Malone and Friend arguing that the reality of the arrangements, based on his auto-cleanse argument, meant that there was some legal obligation to provide work or accept work offered, and we disagree. And then you've seen that paragraph as to why they disagree. I'll come to the detail in a moment, but 146, next page, they also look at other factors which might imply some level of obligation, so the merit payment arrangements rejected in 146. And they then deal with some cases that Mr. Norbat then relied upon but hasn't pursued here, as to whether it could be seen by analogy with St Ives or Addison, Lee and Gascoigne that an expectation to do work had crystallised into an obligation to do work. And the tribunal correctly recognises that that might be the case, but whether or not it was a question of fact. And that's what they say at 149. These cases are of no great assistance. Each case turns on its facts. They say there was no express provision negating an obligation to provide or accept work. That's true. And then in 149, they're meeting Malone and Friends' contention that there was some auto-cleanse reality or wider factual circumstances that would allow the conclusion, indeed dictate the conclusion, that an expectation had crystallised into an obligation. And that's what they reject at 149 through to 151. The exercise the First Tier did was to identify written terms, identify other relevant factors that might bear on the question of the content of the overarching contract, consider Malone and Friends' contention that surrounding factual circumstances meant the reality was that terms should be added, and rejected that contention on the facts. Now, if it's right to approach that as a matter of fact, then that conclusion of the First Tier Tribunal becomes very difficult to appeal. Not impossible, but very difficult. So what then is the legal framework against which the First Tier carried out that exercise? In particular, were they right to regard the exercise of looking at the auto-cleanse reality to see what terms might be found to add to the written terms to constitute the overarching contract? Were they right to see that as an exercise of fact? Answer, on the authorities, yes. And we can see this starting in Carmichael. I invite you to take up volume 1 of the authorities, tab 16. This is the decision of the House of Lords about the guides at the power station who worked from time to time as they might be required. The argument was whether working on a casual basis as required would give rise to employment protection in circumstances where they would have to spell out some overarching or umbrella contract. And the tribunal in that case had made various findings that are recorded succinctly by Lord Irvine, it's page 204 of the bundle, page 2045 at letter G, where the tribunal made findings based on certain documentation, the way it had been operated and the evidence of the parties as to how it had been understood. And in particular at letter H, the tribunal had recorded that the parties incurred no obligations to provide or accept work, but at best assumed moral obligations of loyalty in a context where both recognised that the best interests of each lay in being accommodating to the other. So that was the relationship between the guides and the, was then the CGB, but became national power. And then just a note to save me coming back to it, top of 2047, letter A, Lord Irvine says that because there was no obligation to provide casual work, nor an obligation to undertake it, there was an absence of that irreducible minimum of mutual obligation necessary to create a contract of service. So can I just invite you to note that, and we'll come back to the significance of that in due course. But on that basis, absent some other circumstance, there could be no overarching contract. And what the House concludes is that there were no other relevant circumstances. But how to approach this question of the content of the contract is addressed more fully by Lord Hoffman. He refers to Lord Devlin's Hamlin lecture on trial by jury about questions of law, so that's at 2048 letter F. And there's mention made of a second category, are questions of fact, which lawyers have decided that judges can answer better than juries. And then Lord Hoffman says, included in the second category is the construction of documents in their natural and ordinary meaning. But, reading over the page at 2049, paragraph that begins, it was this rule which the Court of Appeal has relied upon. And he says that between letters B and C, the Court of Appeal pushed the rule about the construction of documents too far. And then this, it applies in cases where the parties intend all the terms of their contract, apart from any implied by law, to be contained in a document or documents. On the other hand, it does not apply where the intention of the parties objectively ascertained has to be gathered partly from documents, but also from oral exchanges and conduct. In the latter case, the terms of the contract are a question of fact. And of course, the question of whether the parties intended a document or documents to be the exclusive record of the terms of their agreement is also a question of fact. So whether the parties intended it to be only written and nothing else is a matter of fact, and the terms of what that something else might be is also a matter of fact. And it is that which leads his lordship to say at 2050 letter D, having said that the industrial tribunal was entitled to find as a fact that the parties did not intend the letters to be the sole record, then says between letters D and D, on this basis, the ascertainment of the terms of the agreement was a question of fact with which the employment appeal tribunal were right not to interfere.
And what about the construction? I mean, once you decide where the parts of the contract are, whether it's wholly written, partly oral, or whatever, so you're able to write down on a piece of paper, derived from those sources, what the terms of the contract are.
Once one has done that exercise,
the construction of those terms is
wooden capita, rainy sky, question of law to be informed by the factual substratum. And there is still a debate about the merits of textualism and contextualism. We're now told they're not inconsistent. And
We know.
Those are perfectly plausible routes to the answer you first thought of. But once, my lord is quite right, once one's done that exercise, I find a written contract that's got clauses 1 to 10. I decide on the facts that I need to add in clauses 11 to 15. I then stand back and say, now I must construe that contract.
Yeah.
But the determination of clauses 11 to 15 is a matter of fact.
Sorry, the decision whether 11 to 15 are terms of the contract.
Yes, the identification of 11 to 15 is a matter of fact.
But the construction of the whole is a question of law.
Is a question of law. Now, take that one step further. It is sometimes said, and it was said in autoclans, that the apparent express terms do not reflect the true agreement between the parties. There's a sense in which sometimes you need to look elsewhere for, quote, the true agreement or the real deal. And that finds expression in order, autoclans, Pimlico Plumbers, Laing, Addison, Lee and Laing, and Uber. But in each of those cases, it is said that the determination of the true agreement between the parties, where you are concluding that is not determined by the express written terms of a contract, is itself a question of fact. Now, you were shown all these cases just this morning by my learned friend. Perhaps if I just show you the first and the last of those, I'll give you the references as we go along. So, autoclans is in the second volume of authorities, that's tab 31. This is in the Supreme Court. Can I invite you, you've looked at this, but pick it up quickly at page 409 of the bundle, paragraph 20. The essential question in each case is what were the terms of the agreement? And then ordinary contract rules are set out. 21, nothing is designed to unpick or hamper or undermine the traditional contract rules. They then left Lord Justice Aitkins in the Court of Appeal at 89, which ends with the phrase that in each case the question the court has to answer is what contractual terms did the parties actually agree? And then that is reiterated at 32 and approved. And 35 makes the point that one of the facts you might take account of is the relative bargaining power of the parties in order to identify, third line, the true agreement. The conclusion in autoclans is at 38, and it rests on the findings of fact. Lord Clark ends by saying, letter E in 38. I also agree with them and Lord Justice Sedley that the Employment Tribunal was entitled to hold that the documents did not reflect true agreement between the parties, and that on the basis of the ET's findings, 4 essential contractual terms were agreed. So that exercise was done, in my example, to add clauses 11 to 15, but it's done on the evidence. And just for your note to save looking at it, but Pimlico Plumbers, Volume 2, tab 41, you will find the same conclusion at paragraphs 111 to 112, 140 and 145, And in Laing, volume 2, tab 49, you will get the same from paragraphs 11, 16, 58 and 63. But then I ought to show you quickly Uber in the Supreme Court, which is volume 3, tab 55. My friend had some observations to make about the nature of the 5 things that Lord Legate relied upon. And I'm not going to quibble with him now, but I do want to say he's wrong about that later when we come to control. Can we just note at page 682 of the report, 942 of the bundle, paragraph 96, in all these respects, he's identified factual findings. In all these respects, the findings of the Employment Tribunal justified its conclusion that although free to choose when and where they worked, at times when they were working, drivers worked for and under contract with Uber. And then 5 aspects of the Tribunal's findings are worth emphasising. So in order to identify the true agreement, the real deal, in that case, the court, Lord Legate, identified those 5 factors from 93 through to 101. And then can we turn to 118? Here he comes back to the Employment Tribunal's decision, bundle page 949. It is firmly established that where the relationship has to be determined by an investigation and evaluation of the factual circumstances in which the work is performed, the question of whether work is performed by an individual as an employee or as a worker or as an independent contractor is to be regarded as a question of fact to be determined by the first level tribunal. And then 119 on the facts found in the present case, and in particular those which I've emphasised at 94 to 101 above, and then the Employment Tribunal were entitled to identify that as being the real agreement with Uber. So the first tier here decided as a matter of fact that the parties intended that their contract would be found in the written materials and in other materials, other factors. And that's the first tier at paragraphs 129, 135, 139, 140 and 140. The first tier found that the terms of the contract, once all its relevant attributes were identified, did not require PGMOL to offer match appointments nor the referees to accept them. And that's first tier paragraphs 52, 104 and 145. And the first tier then determined that the parties' dealings and their expectations did not amount to legal obligations to offer work or to do it. And that's the first tier at 104 and 145 to 149. So the first tier concluded that the express written terms did not here fail to reflect the real agreement between the parties. And that's the first tier at 150. Now, once we know that those are matters for the fact-finding tribunal, if my learned friend wants on this second appeal to repeat his contentions that expectations should be read as obligations, he has to persuade you that the first tier erred in an Edwards and Bairstow sense, by taking account of irrelevant considerations or not taking account of relevant considerations or arriving at a conclusion that was perverse on the evidence. And in order to do that, he needs to show you the evidence. To do that Edwards and Bairstow exercise, if the contention is that the first tier have found facts that were not justified by the evidence, you need to see the evidence. Lord Justice Henderson mentioned the Chippy case, Giorgio and Mario's Chippy, so that case about the operation of this Edwards and Bairstow rule. And that does require the appellant who complains about the fact-finding tribunal to identify exactly which finding of fact is complained about, or inference from fact, and also what evidence bears on that exercise.
Can you just help me on one aspect of this? I mean, I follow that argument if what one is dealing with is a finding of fact, such as in the cases you've just shown us, to the effect that some of the terms are derived from whatever it is outside the written documents, which on, as a matter of authority, would be a fact, a finding of fact, and then you're going to disturb that, you're going to be into the sort of Edwards and Bairstow type exercise you're referring to. But I think I detected in Mr. Norbat's submissions, at least in part, I'm not quite clear yet whether that was where he ended up, that some of his argument about whether there was this obligation could be said to be based on an implied term. I mean, that's one way of putting it, derived from the terms, the terms of the express terms of the written documents that we were shown.
That's how he put it in the first tier, and
Yes.
there were, I wasn't in the first tier, but you can see that from the decision. That is how it was put in part in the Upper Tribunal.
Yes.
But it's not an exercise of implying a term that's otherwise in the ether into a written agreement. What he wants to say is there's a term in a document that is expressed to be a matter of expectation, which the tribunal finds to be of expectation and not of legal obligation. He wants to alter the characterization of that rather than imply it into a written agreement.
Well, I can see that so far as that argument has to have a factual basis, then the tribunal has to make or not make whatever the relevant finding of fact is, and you can't attack those findings of fact except in the way you've described. But there is quite a debate, isn't there? I mean, if you can sometimes imply terms on the old Moorcock sort of basis of, you know, the man in the street, if he read these terms, would say, oh yes, of course, that must include X, Y, and Z. Now, that, I think, if that is a possible approach, would be a pure question of law, wouldn't it?
Well, that would be akin to the Liverpool City Council and Irwin type
Yes.
argument. It's the figure who sits over the drafter's shoulder and
Exactly.
says, of course you mean this.
I mean, you know, we don't have to get into the debate that's pervaded the Supreme Court about C. Lord Hoffman, about whether the implication of terms in that way is simply part of the process of construction or some different exercise. But either way, it is a legal question.
My lord, that would be, but that's not what is either A, said here, or
No,
B,
well, that's-
necessary here.
No, well, that's
Because
the
even
point.
if it were to be said in reply, it doesn't, it's not the appropriate analytical technique for where my learned friend wants to go to.
Right.
What he has to say is that the first time we heard this argument, my friend ran an auto-cleanse argument and said that the reality or the real deal here is that it says expectations, but realistically it should be seen as an obligation. Obligation to offer matches, obligation to do some of them. Rejected by the first tier on the evidence. And that's not an exercise in a Liverpool City Council sense of implying a term. It's an exercise in recharacterising the first tier's findings as to the nature of that term.
And presumably, I mean, the evidence relevant to that issue will have included, I mean, a lot of the evidence in chief and cross-examination of the referees themselves.
Yes.
I mean, because that is really all feeds into the FTT's conclusion that in this particular, very unusual factual type of case, it's enough to rely on the self-motivation of the referees without having to have a contractual carrot and stick approach on this aspect of the relationship.
Exactly, yes. Mr. Riley, who gave evidence, was asked questions by Malone and asked questions by the judge about exactly how did that dynamic work when he had so many matches and he needed so many referees and he's got so many people available. Yeah. How did he manage all that? And his evidence was, well, I can manage it, and the way it worked is I've got a lot of driven people and I've got a finite number of matches.
Yeah, because they presumably wouldn't want to put themselves through that regime if they weren't keen to referee matches.
Yes, they are all quite mad about doing this.
Yeah. Yes.
Mad in many senses, once.
And a lot of them, I mean, I understand it to be the case, have very full-time jobs as well, often very demanding full-time
Nearly
jobs.
all of them.
Yeah, so it's not as though they're part-timers and, so to speak, in their day jobs, far from it.
No, they are juggling work
Or at least some of
commitments to allow them to go to Accrington Stanley on a wet Tuesday night in February for a few £100.
I didn't know. Are they? I thought Accrington Stanley would have been disappeared.
My lord, they had to look this up. They had, and they came back. In the years we're concerned with, I think they were in League Two.
I was actually wondering what the level of the fees was in rough terms. You said a few £100. It's not actually mentioned in either decision, I think. It's not strictly relevant, but just quite interesting.
I think the totals.
I think it's somewhere between £300 and £400 a game.
Thank you.
I'll
So
be
that's
told.
the right order of magnitude, anyway. Thank you.
It's a few hundred. And yes, it is. Football is important in this country for obvious reasons, and League One and League Two are important. But this is not the Premier League or the Championship or the glamorous rounds of the FA Cup. These
It's
are the
every level below that, is it? From
in the years we are concerned with, some of them refereed in the Championship, the old Division 2,
yes,
but otherwise it was the two divisions below.
yes.
But not in the Premier League then and now is refereed by the select group, who are employees of PGMOL.
Yes, yes.
But there are also the worst tiers lower down. I mean, the ones all these referees have worked their way up through, which are below the tiers we're now talking
Absolutely.
about.
There are 30, in the years we're concerned, there are 30,000 referees.
Yes.
the
So
country.
if we're thinking of a pyramid, well, that's the second layer down, as it were.
We are. And starting at junior football, Sunday League pub football, county football, the semi-professional game, and so on.
And so on, yes.
And the Premier League referees don't get demoted.
They do, can be demoted. It happened to one of them, and then he was re-promoted.
I see. Right.
But significantly, as regards this overarching contract, it was a hard-fought fight on the evidence as to the nature of the relationship between the cadre of referees and PGMOL, and the first tier made its findings a fact. So once that's accepted as being within their province, even in a world where as a matter of law the authorities show that expectations can crystallise into obligations, the questions in a given case are, did it happen here? First tier say no, absent some Edwards and Bairstow error, that is the end of that debate. And that in effect is what the Upper Tribunal recognised here, and so they deal with that in their judgment relatively shortly. But just for your note, Part F, paragraph 71, 71 onwards, ending at 96. And indeed, they capture absolutely accurately the tenor of my learned friend's complaint in the Upper Tribunal. In 96, we consider that the Commissioner's real complaint is that it disagrees with the conclusion the FTC reached.
Yeah.
And they say, well, we found no error. And in particular, to adopt a phrase that's in the St Ives case we haven't actually looked at, but is there a sufficient factual substratum to support the first tier's finding at 150? Answer, yes. Therefore, no good ground of appeal. So that is our short answer on the umbrella contract mutuality argument. And the beauty of that argument is that it doesn't depend on exactly what is meant by this concept of mutuality. Because in that regard, the debate is elsewhere. So then let me deal with control. Now, here the court may well have picked this up, but we're only concerned with control in the individual engagements. So the first tier said there was no sufficient control in the overarching contract, and that's the first tier at paragraphs 165, 166 and 169. And the Commissioners didn't challenge that on appeal to the Upper Tribunal. So the only appeal to the Upper Tribunal was in relation to control in the context of the individual engagements. Now, there is no debate now. There has really been no debate as to the relevant principles to be applied when addressing this question of control, nor is there any real debate that the first tier identified those principles correctly. The Commissioner's case in the Upper Tribunal was that the first tier had misapplied those principles, and it was that case that the Upper Tribunal accepted. The relevant principles are summarised by the first tier in their paragraph 163. So if you have that to hand, in order for the individual engagements to be contracts of employment, there must not only be mutuality, but also a sufficient framework of control in relation to that engagement, as Montgomery. This means some contractual right of control, in the sense of the employer having the right to step in, even if that right is not exercised in practice, even if the individual is engaged to exercise his or her own judgment about how to do that. And there they cite from White and Troutbeck, which we have in the bundle, both in the EAT and the Court of Appeal. But for our part then and now, we regard that as a short and accurate summary of the principles. If you then turn up the Upper Tribunal's decision, they seek to identify the relevant principles in paragraphs 131 through to 138, just so you can see that they're saying the same thing. 130, they say there are 4 related questions. First, did the first tier correctly apply the test of whether PGMOL had the right to step in and give instructions to referees? And then second, third and fourth questions are points of detail I'll come to in a second. And then 131, this right to step in, they cite from White and Troutbeck, upheld in the Court of Appeal. And paragraph 40 from White and Troutbeck, the key question is whether there is, to a sufficient degree, a contractual right of control over the worker. The key question is not whether in practice the worker has day-to-day control of his own work. And then 41 makes the now modern point that in the modern working world there are lots of people who may well be left to get on with their jobs. But that doesn't necessarily mean that they are not subject to control. (132) cites from Wright and Aegis, referring to the High Court of Australia in the Acrobat case, its use. So 132 and 133, in effect, you've seen from a learned friend. 134, reiteration that nevertheless it remains essential that some sufficient framework of control exists. And they then refer to a case called Krista Ackroyd Media about a radio presenter, or a television presenter, which makes the point that we're not here looking at granular mechanics of control, but making the point that what mattered in determining control was not the practical exercise of day-to-day control and whether actual supervision was possible, but whether ultimate authority over the man, or in that case woman, in the performance of his/her work resided in the employer. And then the Upper Tribunal say in 135, these authorities established that a practical limitation on the ability to interfere in the real-time performance of a task, served in a chef, football or live broadcaster, does not of itself mean there's not sufficient control. And then just finishing that exercise off, 136, these authorities appear to contemplating a relationship of a longer term than a single engagement. That might make a difference. And then 137, the critical question in this case, where the period of the contract ends with the submission of the referee's match report shortly after the final whistle, is whether the absence of an ability to step in to regulate the referee's performance of his core obligation, officiating the match or to impose any sanction until after the contract has ended, means there is not sufficient control. I think that's to mischaracterise the question slightly for a reason I'll come on to. And then in 138, they arrive at their conclusion on the authorities, and in particular line 11, we consider that the test requires that the putative employer has a contractual right to direct the manner in which the worker is to perform their obligations, and that those directions are enforceable in the sense that there is an effective sanction for their breach. So we are quite content with both the first tier and the upper tribunal statement of the principles. The upper tribunals is slightly greater length, but to the same effect. So we say, indeed we believe it to be common ground, that the relevant notion of control is a sufficient framework of control in the sense of the alleged employer having the right to step in so as to be master, even if the nature of the role being performed is such that there is no practical ability to step in real time. So to that extent, we accept and endorse the Upper Tribunal from 131 through to 138. Although I don't accept the way the Upper Tribunal encapsulate what it sees as the critical question in 137. Now the question in this court, acutely, is whether the Upper Tribunal were right to conclude that the First Tier had erred in its application of these principles. Now, the Upper Tribunal come to the conclusion, yes, it had erred in the application of those principles, but the Upper Tribunal, as you now well know, did not say that there was control, but merely that the First Tier had erred in concluding that there wasn't control. And what the Upper Tribunal accepted was my learned friend's case, that the First Tier had erred in their paragraphs 168 and 169. But in order to see just what is said to be their error, I invite you to take up the First Tier again and start at paragraph 163. So 163 we've seen, it's their statement of principle. Mr. Morm had an argument about regulatory control, and referees were like clergy, they were beyond control. Mr. Norbat's case was there was a sufficient degree of control, including via the assessment and coaching systems. And the First Tier find 165 that the pre-season documents, including the fitness protocol, matchday procedures and the code of conduct, imposed some obligations on referees which gave PGMOL elements of control. Some of those obligations applied to matchday activity. So this is match day, not just the 90 minutes of the game, because the matchday procedures prescribe what was expected of referees in relation to their conduct on match days. Now they go on in 165, others, so other documents such as contact with the sports scientist, clearly did not apply in respect of individual match appointments. So they're recognising there's some control. 166, they deal with the assessment and coaching argument. They're not persuaded that they provide further elements of control in respect of individual match appointments. They say that because those assessment and coaching systems were advisory or designed to support and assist the referees, but it was advice and not an indicator of control. End of 166. .167 makes the point that the referees had some control over geographical locations for their work, because they could express that on the appointment system, MOAS, but also they had the ability to refuse a particular appointment or even to back out later. So they say in 167, line 37, this was not the sort of arrangement under which PGMOL could direct the referees about where to go or when to go there, or indeed what task to perform when they got there. In each case, the referees needed to agree to take on a particular task at a specified location, date and time. Now, nothing was said to be an error in relation to paragraphs 165, 166 and 167. What was said to be an error by my learned friend and accepted by the Upper Tribunal was their paragraphs 168 and 169. And in particular, it was said that the First Tier had focused unduly on the match itself, so the 90 minutes of the playing time, no doubt plus half time. It was also said that they paid insufficient attention to the pre-season documents that made up the overarching contract. And it was also said that they paid insufficient attention to the assessment and coaching of the referees. And that is, those were the contentions made, is set out in paragraphs 124 to 127 in the Upper Tribunal's decision. Now, the Upper Tribunal rejected the complaint about assessment and coaching. That's in paragraph 129 of the Upper Tribunal. So there was no error of law in relation to the first tier's paragraph 166. Equally, there were said to be no errors of law in relation to 163 or 167. But the Upper Tribunal then found that there was an error of law in relation to 168 and 169, and the reasons for that are set out in the Upper Tribunal's 139 to 141. Now, in order to test that, if we take up the first tier decision, if I go back one step, the allegations made by my learned friend and accepted by the Upper Tribunal were that 168 and 169 confused the ability to step in with the right to do so, and confused the position during the match engagement with the position during the match itself, and failed to give proper weight to PGMOL's rights under the overarching contract. Now, each of those contentions is in effect a contention that the first tier have misunderstood the evidence or failed to address the evidence, or failed properly in the evaluative exercise in relation to the evidence. And each of those, I say, is groundless. So the first tier was alive to the distinction between the practical ability to step in and the right to do so. First tier did not focus just on the 90 minutes of the match, but on each match engagement. And the first tier was aware of and considered and weighed the significance of PGMOL's rights under the overarching contract. And that latter contention, as well perhaps as the others, is a classic Edwards and Bairstow challenge, which the Upper Tribunal should not have accepted in the absence of a review of all of the relevant evidence. So taking those in turn in a little more detail, were the first tier guilty of confusing the ability to step in with the right to step in? Answer, we say no. The first tier make clear in 163 and in 168 and 169 that they are alive to the distinction between the ability to step in practically and the right to do so. And their conclusion is that there is no right to do so. And they base that on the fact that the laws of the game gave the referee final authority in connection with the match. It's not just the 90 minutes, it's the time outside that as well as part of the match engagement. It's the referee's decision the pitch is unplayable, of the match has to be called off, or if there's a security problem. All of those are left to the referee. He is in control on match day, not just the 90 minutes plus half time. And there was evidence before the first tier to that effect in the witness statements of Mr. Perkis, Mr. Sarginson and Mr. Brooke. That's one factor. Secondly, the first tier was alive to the fact that the referees owed obligations under the Code of Practice to the FA. Equally, the referees owed obligations under the referee regulations to the FA. And it is the Football Association that deals with breaches by the referees, not PGMOL. And that is reflected in the first tier's conclusions in paragraph 168. Now, we do not say that the Football Association had exclusive control over the referees. But the question here is of ultimate authority. And the ultimate authority here for the referees is the Football Association. And it is those facts taken together that allow the first tier to say in 168. In reality, it is hard to see how PGMOL could retain even a theoretical right to step in while a referee is performing an engagement at a match. It's not that there was an inability, a practical inability to step in, based on the inability to interfere when the referee was on the pitch, but no right to step in, given the nature of the laws of the game, the Code of Practice, the referee regulations, and the obligations owed to the FA. So the first tier was alive to that distinction and focused on the right concept, the right to step in, and determined that there was no right to step in. So that first criticism made of the first tier is not well founded. Related to that is the second criticism made, that the first tier must have been thinking about the 90 minutes of the match, where no one controls the referee is in charge. But that's not right. The first tier were alive to the fact that the individual engagements started when the referee accepted the offer on the MOAS system. Let's assume on a Tuesday before a Saturday, and the individual engagement ended once he'd filed his match report, whether that was Saturday night or early Sunday morning. So that's the match day engagement. First tier were very much aware of that, and what they test in this part of their decision is control of the referees under the individual engagements, where each individual engagement was an appointment in relation to a particular match. But that is not to focus just on the 90 minutes of the game itself. And that's why in 169, why they say in 168, line 9, at most they, PGMOL, could offer advice at the time and take action after the engagement has ended. And they make the point in the last sentence of 168 that nobody could interfere in the referee and remove him at half time, but that's not all that they address. 169 we are not persuaded that PGMOL had a sufficient degree of control during and in respect of the individual engagements. So my learned friend's case was that when you see reference in 168 and 169 to individual or match engagements, the first tier must have been thinking about the 90 minutes of the match, and that's just not right. First tier were alive to that distinction and tested the right thing. So what they say in 168, well, you have to look at the nature of the role that's being performed. The referee is undoubtedly the person in charge on match day, that's true. The referee has obligations to the Football Association, who are his regulator. PGMOL has no right to step in. PGMOL can offer advice and take advice after the engagement has ended, but not during it. And then in 168 they say, overall, this is the conclusion of their evaluative exercise, overall we are not persuaded that PGMOL had a sufficient degree of control. So they're recognising that there are some elements of control, but they are determining that it's just not sufficient in their view. Now that is an exercise in addressing the legal question, is there sufficient control? But in circumstances where it's not said they've got the principles wrong, then the application of those principles, where it is here significantly driven by factual matters, is a matter for the fact-finding tribunal. It's classically an evaluative exercise with which a higher court should not interfere absent an Edwards and Bairstow mistake. If we then turn to what the Upper Tribunal say, in a world where my case is that absent an Edwards and Bairstow mistake, you must respect what is said in 168 and 169. What then did the Upper Tribunal say? And here we need to pick that up in Upper Tribunal paragraph 130. Well, let me go back to 137. Why do I say they misstated the crucial question or the critical question in 137? They correctly identify that the contract ends with the submission of the match report, but they assume that the core content of that contract is only the referee's performance of his core obligation, officiating at the match. So there, the Upper Tribunal are focusing only on the match itself and not the match day engagement. So they misstate the critical question. Then in 139, accordingly, and in answer to the first few questions we have posed in paragraph 130 above, we consider that the first tier, in relying at 168 and 169 of the decision on PGMOL's inability to step in, and on PGMOL's lack of ability to exercise the correlative rights during an engagement, they are ascribing there to the first tier a decision the first tier did not make. They are reading the first tier's decision as one based on inability to step in, or a lack of ability to exercise correlative rights. What the first tier had actually said is there's no right to step in, and under the mechanisms provided for by the various contracts, there was no right. PGMOL was not in a position to exercise correlative rights during an engagement. So in 139, the Upper Tribunal are mischaracterising, misreading what the First Tier actually said. And equally in 139, they say, the fact that PGMOL could only impose sanctions after the end of the engagement took into account irrelevant considerations. Well, that is at least a relevant consideration. Because if, as a putative employer, your only ability to discipline or to sanction or to comment on the behaviour of a putative employee is after the engagement has ended, that is a material consideration in addressing whether there is control during the engagement. It may or may not be a strong factor, but it is at least a relevant factor. So the Upper Tribunal were wrong to say that it was irrelevant. Instead, it was a relevant feature that the First Tier were entitled to weigh.
Is that the case even in a situation where there's an overarching contract?
Well, in those circumstances, the position would be different.
Because there is an overarching contract here.
But it would be different if there was a right under the overarching contract.
Right.
Maybe I misunderstood my lady's question.
No, I think I can see what you mean.
But here the allegation is only that there's, because the First Tier have found there's no control under the overarching agreement, and that was not challenged. So against that background, the contention is that we have control during the match day engagement.
Yeah, I see.
So our lack of a right to sanction, discipline or comment on the behaviour of someone during the engagement is a material factor.
And it will often be the case, but particularly with very short engagements, I mean, shorter than those we're dealing with here, that in practice any control can only be exercised retrospectively after the engagement is finished.
Well,
But that doesn't mean there's no control.
well, I quite accept that, but what that tells us is that that is a relevant factor to be weighed in the balance.
Yes, I follow that. It's not ruled out merely because you can't step onto the pitch during the course of the match itself
Well, look, yes.
and tell the referee to get lost or he's got it all wrong.
Yeah, so in other words, you're criticising the statement by the Upper Tribunal that they took into account irrelevant factors when, yes, I
Yes.
see that.
And my lady, in a sense, to justify their conclusion, the Upper Tribunal have to say it was irrelevant. Because if it's relevant but they just wouldn't have given it the same weight, they are interfering in the evaluative exercise of the First Tier without justification. So my learned friend had to say it was irrelevant, and the Upper Tribunal, in this regard, has to agree that it was irrelevant. But then in 140, just reading on of the Upper Tribunal, they say separately we consider that the First Tier also erred in the first two sentences of 169 in concluding that if an issue emerged between the commencement of the contract and match day itself, there was no control during an engagement, because PGMOL's only remedy was to terminate the contract altogether. In such a case, PGMOL would be stepping in during the period of the contract. Well, that, in a sense, is true, but what the First Tier are doing in 169 is weighing up all of these factors and saying that overall they were not persuaded. So they are right to say it is relevant that the only sanction that PGMOL could impose for failure to adhere to various commitments was not to offer further match appointments.
So, I mean, is your main point, Mr. Peacock, is that they've simply misread what the way the FTT approached this question.
Oh Lord, yes.
They've looked at it as they've read it as far too narrow a focus by the FTT on what control was available whereas you say on a fair and proper reading of it, it did take into account the period of the contract.
My lord, yes, and that fair and proper reading has to extend to all of the first tier's decision, because they very properly lay out all the facts, they test the evidence, they then draw conclusions, and yes, here they're drawing conclusions under the heading control.
Yeah. And so another aspect of this is if one finds what looks at first blush like, or may look like, a slightly infelicitous expression, giving the impression they were just looking at the 90 minutes of the match itself, one has to credit them with the common sense of realizing that, of understanding that they were looking at the question in the context of the entire engagement they had themselves identified.
My lord, yes.
Which began on the Tuesday and ended usually on the Saturday.
Yes.
And one shouldn't, so there was a danger of being over-influenced by a sentence taken out of context, which might appear to betoken an unduly narrow focus on the match period itself.
My lord, yes, and the most visible way of testing control is, of course, to ask the question, could you hook the referee at half-time if you didn't like the way he was officiating the match? But that's not the question.
I see, yes.
It's an easy question with an easy answer, but it doesn't, in fact, give effect to the relevant principles. So you have to look, as the first tier we're absolutely alive to, the whole engagement, and then weigh up the degrees of alleged control in relation to that engagement.
And does it follow from this, just to think it through a little bit, that if you're right about this, and the Upper Tribunal had no basis upon which to interfere with the First Tier Tribunal's conclusion on control in relation to the individual engagements, then that means that the appeal must fail whatever the position in relation to mutuality of obligation.
My lord, I was going to dangle that carrot at about 10 past
Yes,
4.
well, I was sorry, I'm perhaps anticipating your passing shot for us.
There is a big and difficult exercise to be done now tomorrow morning, where we have to get to grips by what exactly is meant by mutuality. But the boot is on the other foot. If I'm right about control, that element is missing, then the first tier were right.
Because that would mean effectively that the second of the ready-mix contract obligations was not fulfilled.
My lord, exactly.
And that is
That's a short answer.
That's a short answer. I'm not suggesting we don't have to grapple with the other questions if we're with you on this one, but it does mean logically, I think, doesn't it, that this does provide a very short route to the conclusion your clients hope to achieve.
It does, my lord, yes. And it is an attractively much simpler point. But of course I recognise that I may not get home on that, so I have to tackle mutuality. But my own friend, this will sound ruder than I mean, but he reads a half a sentence here and half a sentence there, and no doubt we all do it. But one does need to read it in its entirety and see the way in which, very carefully, they weighed the evidence and addressed the relevant issues here, common ground, by applying the right principles. We do say with respect to the Upper Tribunal that they have interfered where there was no basis to interfere. So they're wrong in 139 and 140. And then in 141 they say, well, the fact that there's an error doesn't necessarily mean that there is control, and of course that's right, and then they leave it for another day because they didn't need to, because we'd won on mutuality. Now, my friend's case, just to draw that last thread on control, was to say that he advanced an argument to the effect that on the facts as found, some tribunal, whether it's this court or some other tribunal, could only conclude that there was control. There's a separate question as to which forum that argument should be had in, but in order to make that good, he has to say, on the findings of fact made by the first tier, that could be the only conclusion.
What do you mean for it to be perverse?
For it to be perverse.
Yes.
well, for it to be perverse and to be corrected by a conclusion that there is control.
Yes.
But in order, let's assume it's this court. In order for this court to arrive at that conclusion, you have to look at the findings of fact. You probably ought to look at some of the evidence on which those findings of fact were based. And then you have to conclude that there is only one possible conclusion, notwithstanding that the first tier's evaluative exercise was the opposite conclusion. And that's an enormously high hurdle for my learned friend to cross. And I submit, on any view, he gets nowhere near that. But if we were going to do that exercise properly, you would need, I'm afraid, to get further stuck into the facts and the evidence.
Well, what used to be said in my days of doing revenue cases, and that type of argument was raised, was this is hopeless without having the transcript in front of one. I mean, how can you form a view on an issue of this kind without looking at all the oral evidence, for a starter?
Lord, yes, and in this case, I didn't appear in the first, but I understand there wasn't a transcript. So
It makes it even harder.
the judge, no doubt, has her notes somewhere.
Yes.
May or may not have been retained.
I mean, there was cross-examination of a number of witnesses,
There was.
or not? Yes, it wasn't just. So it's not as though it was the case where it was all in the witness statements.
No, there was cross-examination. So my learned friend is attempting to scale a very, very high peak there. As to which court or which forum that argument might be had in, you have my submissions to the effect that we don't get there. If you were against me so that you have to tackle this, in one sense you are best placed because you have most recently the principles in mind, but in one sense you're worse placed because you're much further away from the evidence. So in those circumstances, and notwithstanding the difficulties, I think if you were not prepared to do it, it would have to be remitted.
Well, it would be very exceptional for this court to undertake that kind of examination of detailed evidence. I mean, that's not what a second tier of appeal is really for. Unless it's absolutely obvious what the answer has to be. But I mean, I'm at the moment finding it hard to understand how that test could be satisfied.
So I think your Lordship's observation that remitting it, and perhaps if a way could be found for Mrs. Justice Falk to sit again in the first tier, and I confess I have no idea whether that is possible, but if it were, that would be a neater solution. Otherwise, we would have to maybe make further submissions if the issue arose as to what the right course might be.
Yeah.
But it sounds as if there would have to be a rehearing, doesn't there?
But there is that danger, because if we're going to look beyond, or at least critically, at the findings of fact, in a world where there wasn't a transcript, then we would be reliant only on whatever notes the judge or judges have retained.
Yeah.
And absent that, then you'd be looking at a rehearing, and that's wildly unattractive to my clients. Important though this issue is, the amounts at stake here are significant, but they're not enormous.
No, of course.
It's a few tens of thousands of pounds. It might just be £100,000, but
Is that all? I thought I saw sort of $500,000 somewhere, a reference. So maybe that was. I may have got that quite wrong.
I'm told it's 100,000 in the years we're concerned with, and the number will be slightly bigger because of the read across to other years.
So is that in each of the years or in all of the years?
But there are two tax years, and it's 100 and odd.
They straddle 3 tax, 2 seasons.
They straddle 3, I think, don't they?
Apparently it's 583,000 tax at stake without interest.
Okay. Well, Malone Friend tells it 583,000 tax, not including interest.
Tax and national insurance, presumably. Well, I mean, that's a slightly, well, I mean, it's not an insignificant sum, but even so, in the context of most tax disputes, it's a relatively modest figure for the degree of expenditure and expertise, professional expertise that would be engaged in
what would be then a fourth hearing.
in what would then be a, yes.
So Perhaps for now, if I leave it that we might be invited to make any further submissions as to an appropriate route if you get that far on the logic. But you have my case that we don't get that far.
I suspect it's the kind of case where further submissions will be much better addressed after we've given you a draft judgment, if and when it becomes necessary to go down that route, rather than attempting to do it all on a hypothetical basis now. But it's helpful just to canvass some of the parameters, which is what we've been doing.
Well, there is some authority which I now can't recall, the gist of which is that you should ordinarily send it back to the same First Tier Tribunal, but there is recognition that that's not always possible, or sometimes not always appropriate.
Well, in a sense, that's sort of common, fairly obvious. But I mean, certainly that's my understanding of the general approach. And one shouldn't be too reluctant to send it back to the same tribunal merely because one has diagnosed an error, and especially in a very difficult field like this where there's an enormous amount of case law, and it's by no means easy for anyone to come to the right answer.
And I would endorse that and reject, I think, the faintly advanced suggestion by my own friend that it wouldn't be appropriate to go back to this tribunal. That shouldn't arise here. It's just a question of practicalities.
Yeah.
But just to dangle that carrot again, if you were with me on control, we can sidestep some of those difficulties, and we sidestep the greater exercise of working out the role and scope of mutuality. And my Lord, I'm conscious that it's not quite 4:15, but I wonder if we might conveniently break there.
I think in view of the fact we've all had to soldier through a very trying day without any air conditioning at all, I'm more than willing to say we can draw stumps now, to use an appropriate metaphor in the circumstances. Provided, of course, you're satisfied, you'll have sufficient time tomorrow to allow time for a reply.
Lord, yes.
Good. Well, in that case, we live in hope that by the morning the authorities might have managed to sort the air conditioning out. If not, I'm afraid we'll have another rather hot day. But I'm grateful to everybody for putting up with these trying conditions and for remaining masked, which I know is extremely uncomfortable in conditions like this. So thank you all very much, and we'll resume at 10:30 tomorrow.